Welcome to Denver Startup Week. I'm Eric Matisik, President and CEO of Highwing and co-founder of Denver Startup Week. I could not be more excited about this year's event, as entrepreneurship has always been the heartbeat of our city. For the community, by the community, for the future of the community is why this event has existed. And now, more than ever, it's important to give back and to educate those entrepreneurs who are building the companies of our future. We're able to bring Denver Startup Week to this community thanks to our sponsors. Join me in thanking our title sponsors: Downtown Denver Partnership, JP Morgan Chase, Prologis, and Zero. Our track sponsors who've made all the great content you're hearing today possible: Battery 621 and Public Works, Capital One Cafe, Colorado Lending Source, Friday Health, Quizlet, Exactly, Zayo, and Zestful. Our headline event sponsors are bringing the excitement this week. Thank you to Wix, Kinzon, MAPR Agency, Obsidian HR, Kickstart Fund, Promontory Mortgage, Molson Coors, and Comcast. Finally, thank you to our partner and member sponsors listed on the screen. Please look out for these companies as you enjoy our virtual Denver Startup Week, and don't forget to use hashtag DEN Startup Week to share your experience and moments of inspiration on social media all week long.
Hi, my name is Matt. I'm the CEO of Zestful, and we're an employee reward and engagement platform for companies and teams. We make it really easy for companies to create fun goals for their teams to complete and share with each other. Things like learning something new, getting outside, or even sharing an awkward selfie. For every goal you complete and share, you earn points. Or pancakes, or lemons, or unicorns. You get to pick whatever the currency is, which makes it a lot of fun. And these points, or pancakes, can be used to redeem prizes like company swag, cash on your Zestful card, or even towards team prizes like virtual happy hours or trivia nights. We created Zestful so that we could stay connected and build a fundamentally better culture no matter where we are. And we hope it can be just as fun and rewarding for your teams.
Hello, everyone. Welcome to Denver Startup Week. First of all, I'm Diane Miles, the DE&I track chair and member of the Denver Startup Week organizing committee. Thank you for joining us for our first ever virtual Denver Startup Week. If 2020 has taught us anything, it's that we are more powerful when we come together as a community to share ideas and help make each other better. And we are here virtually showing the world what Denver is made of. At Denver Startup Week, we strive to make all of our sessions a space where attendees can connect, learn, and grow, regardless of age, gender identity, gender expression, race, ability, sexual orientation, or the combination of any of those. There is something for everyone at Denver Startup Week, and thank you for joining us. Thank you to our sponsors for their support in helping us to keep Denver Startup Week free and accessible to all. It has been amazing being the DE&I track chair for the first time ever. This is the first time this position is here, and I'm excited to see where it goes and all of the amazing things that we do next year, and even bigger and even more diverse. Now let me turn it over to our session organizers to take it away. I hope you all enjoy.
Hello, my name is Chris Weiss, and this is the Trademarks of Tiger King, a presentation as part of the founder track for Denver Startup Week. Let's start off with a pop quiz. What led to the financial ruin of Joe Exotic? Was it A, serving expired Walmart meat to guests? Was it B, paying a hitman $3,000 to kill Carole Baskin? Was it C, an employee losing a hand to a tiger? Was it D, polygamy, or was it E, trademark infringement? That answer? E, trademark infringement led to the financial ruin of Joe Exotic. So what will you take away from this presentation? We'll go over how a trademark infringement lawsuit stopped Joe Exotic. We'll go over the elements of a trademark. We'll help you identify and protect your own trademarks, and let you know how to avoid getting sued for trademark infringement. Quick disclaimer, this is not legal advice. So, a little bit about me. I'm an intellectual property attorney, and I've been an attorney since 2012. I work on patents, trademarks, and licensing. I live here in Denver, Colorado, by way of California and New York. And I wrote a book called Key to IP, Identifying Your Patents, Trademarks, Copyrights, and Trade Secrets. I found that a lot of the clients I dealt with didn't have a great understanding of the difference between all the different types of intellectual property. And a lot of that is because if you look at the news, every time there's some news story about trademarks or patents, they'll often mix them up. So they'll say, oh, someone wanted to get a patent on their name, or someone wanted to get a trademark on their idea. So let's just quickly go over some of the different elements of it to help clarify that, so you know exactly what we're talking about when we're talking about the trademarks of Tiger King. So it starts with something. You have a great blank. Maybe it is an invention. If it is an invention, you have to think, is it useful? That doesn't mean it's not useful, but useful in the sense of, does it have any utility? There are inventions called design patents which just focus on the way something looks. So you might have an idea for a new type of packaging or a new type of user interface, and it doesn't go into any of how that actually works. It's just the look of it itself, the aesthetics are what are patentable. And if that's the case, that great thing you have can be covered by a design patent. And you go down the flow chart to, is it complete? Sometimes people have great ideas and they say, okay, I came up with something and I'm really excited to protect it, but it's not quite there yet. It's not ready. They're still working some kinks out, but they want to protect it. One thing you can do is file it for a provisional patent application. A provisional patent application essentially saves your date for 1 year. So you have 1 year from when this provisional is filed to file a full non-provisional or international application. So it's a good way to keep your idea safe before you talk to investors or sort of share with other people to find out how viable it is. So if it is complete, do you want international protection? Some people just want to protect in the US, and if that's the case, you can file for a utility patent application or a non-provisional patent application. If you do want international protection, you can file for a patent cooperation treaty application, or PCT. You can also file a PCT application within 1 year of any initial filing, whether that's a provisional or a non-provisional. So it gives you some time to maybe think, you know, I'm only interested in the US, and later you find out there's a huge need for this great thing you've come up with in Italy. Well, now you can pursue Italy if you want to at that time. So if it's not an invention, what is it? Is it words? If it is words, then think, is it more than a sentence? So something like this presentation that I'm giving right now to you is a whole bunch of words and a whole bunch of images, and so it's not just something nice and short. But if it is more than that, then that would be covered by copyright. So this whole presentation has a copyright on it automatically. The words I'm saying in a transcript would have a copyright on them. What if it's not more than a sentence? What if it's just something nice and short, like Denver Startup Week? Well, Denver Startup Week is a trademark. So the difference in a sort of broad way of looking at it is that a trademark is a very short sentence or phrase or few words, and a longer work is covered by copyright. So what if it's not words, if it's an image? So is it a logo? Is it perhaps the Denver Startup Week mountain logo? If that's the case, then that is also a trademark. If it's not a logo and an image, then it could be covered by copyright. If you took a screenshot of this video right now, that screenshot could be covered by copyright. So if it's not words and it's not an image, maybe it's a secret. If it is a secret, it could be covered by trade secrets. And trade secrets are basically anything that you keep secret from other people. The secret formula for Coca-Cola is a very famous trade secret. The herbs and spices used in KFC would be another example of a trade secret. So what if it's not an invention, it's not words, it's not an image, it's not a secret? No idea. You've got to figure it out. Maybe it's something else. All right. Moving on. Our story starts in 2009. Joe Exotic, as we'll call him from this, purchased a farm in Oklahoma, and he turned that into a zoo, which he named the Gerald Wayne Exotic Animal Memorial Park. Really just rolls off the tongue. He realized his issue and renamed it as the Greater Wynwood Exotic Animal Park. Can't even say it. Also known as the GW Zoo, and that's how we'll be referring to it in this presentation because the other parts are way too much to remember and get into. All right, then in 2010, not shortly long after, Joe got into some battles with Carole Baskin. Joe took his zoo on the road. He drove from mall to mall, offering paying customers the chance to get their photo with a baby tiger. To give you some context of why that might be important, in June 2010, Facebook had just reached 500 million users. So a lot of those users wanted a good profile photo, and what better than a photo holding a baby tiger outside of a Cinnabon in your mall. So Carole Baskin at this time objected to Joe's traveling tiger exhibit and asked her followers to contact the mall and try and get him kicked out of his previously scheduled obligations. So what did Joe do? GW Zoo gets a new name. Joe decided to brand his traveling mall company as Big Cat Rescue Entertainment. Joe posted on Facebook that he registered the Big Cat Rescue Entertainment name so BCR Corp., which is Carole Baskin's corporation, could ruin its goodwill on Google all by yourself, and it is working. Doesn't make sense to me, I've read that many times, but to Joe, it made sense to him. And what he was essentially trying to do is he was trying to confuse people into thinking that Carole Baskin's company was the one putting on this traveling zoo by using a very similar name. So for the purposes of clarity going forward, I'm going to call Joe's company, and Carole's corporation, Carole's corporation, or Carole's company. So what is a trademark anyway? I've heard him described many different ways. One of the best ways I've heard of it is that you can think of trademarks as adjectives. So think of the space in front of a noun. How would you describe sneakers? Well, you could take the sneaker and say it's a black and white sneaker, or maybe it's a high top sneaker, or maybe it's a Converse sneaker. So Converse is the name of a company that makes sneakers, and it is the indicator of the source of those sneakers. So as a dictionary definition, trademarks are the source of goods or services. The trademark is a word, name, symbol, or device that is used to indicate the source of goods or services and distinguish them from the goods or services of others. So technically, trademarks are for goods while service marks are for services, but the term trademark is often referred to use both trademarks and service marks, and the term mark can be short for both of them. So, the trademark, for the general formula for it, is a trademark is a mark plus the goods and or services that are related to it. So you have something like Denver Startup Week, it has the mark Denver Startup Week, and the goods are putting on presentations for giving people information about startups. So let's look at Carole's trademark. Carole has the registered trademark number 2918642 for Big Cat Rescue, which is stylized, including the following three services: charitable fundraising services in class 36, animal rescue services in class 39, and entertainment services, namely animal exhibitions, educational services, namely providing instruction in animal conservation and care. So the issue with Joe comes in on this third class, entertainment services. 2011, you've been served. So Carole's company sued Joe's company in federal court in the Middle District of Florida. And Carole alleged that Joe was infringing her registered trademark, that one we just went over. So, why do you need to protect your trademarks? Well, it might be obvious to some, but if not for others, there is no trademark police force. Companies must enforce their trademark against others, such as by sending out cease and desist letters or filing lawsuits, or their mark could be genericized. So what does that really mean? Is that really a risk of something happening? Genericized is when a mark that used to be a brand name, something that's an adjective to describe a type of good or service, just comes to describe the general class of goods or services. So here's some examples on here. So the widely known example, Aspirin. Right now you can buy Bayer brand aspirin, but you can also buy Safeway brand aspirin. And the reason for that is that aspirin used to be a brand name held by the Bayer Corporation for acetylsalic acid. And what happened was that, so aspirin used to be a brand name held by the Bayer Corporation for acetylsalic acid. And what happened is that other people started selling acetylsalic acid under the name aspirin, until eventually aspirin was just a generic name for acetylsalic acid. So you can buy aspirin from any corporation. Some companies sometimes think it's a good thing when people use their name as a sort of general catch-all to describe things. When someone says, oh, just Google it, they might think, oh, Google must like that because it's free advertising, but Google doesn't want people to just think of any type of searching as Google it, because then that means that the term Google could become generic for searching. So Google would want you to take an internet search using the google.com product. You don't want to go Google it and then go to bing.com and search, because then that could be using Google in a generic way. So, is any of this confusing? As you'll see here, on the left we have Carole's company, Big Cat Rescue. And on the right we have Joe's company, Big Cat Rescue Entertainment. When you're looking at a likelihood of confusion between marks, you have to look at the marks in their entirety. If you start dissecting things, you can talk about a lot of differences, but the real issue is this something that is confusing? If you have Clorox bleach sold on the shelves, you can't say Clorox other non-bleach cleaning products underneath it, because people will think that's also made by Clorox. So let's look at these marks right here. Big Cat Rescue has Big Cat and big letters on the top, and then Rescue underneath, where the B and the T are sort of grouped around the rescue underneath it. If you look at Joe's mark, Big Cat Rescue, the B and the T extend a little bit further down. There's a line underneath it, and they do have entertainment. But it creates the same general appearance to them. So someone would see these two and think, oh, Big Cat Rescue Entertainment must be associated with Big Cat Rescue. There's also a couple other things in here that Joe did that are trying to cause confusion. They did use a snow leopard, which was taken from Carole's website. And also, if you notice in the bottom right, this is actually a business card he was handing out. They put Florida office. So Joe is based in Oklahoma. That's where his GW Zoo is located. But he put Florida office, and he got a Florida phone number. So people would even further, if they weren't just taken by the logo itself, they would look at Florida office and the Florida number and think that it was related to Big Cat Rescue, which is located itself in Florida. So, 2013, the damage. Remember, this lawsuit was filed in 2011. In 2013, after only 2 years of litigation, the parties entered into a consent agreement. Basically, they say, too expensive, I can't keep fighting this anymore. We agree to a settlement so you can stop paying the lawyers and start paying, whatever damages are there. The court held that Joe Exotic Company infringed upon the trademark rights of Carole's company. The court also issued a permanent injunction against Joe for the use of Big Cat Rescue trademark or any confusingly similar marks. Now, normally this is just a catch-all, so someone doesn't come back and say Big Cat Entertainment with 2 T's instead of 1 T. But for Joe, this was probably a pretty needed aspect to that. Now let's talk about the money damages. So this lawsuit did involve both trademarks and copyright infringement. There were some charges for copyright infringement. However, the fee was only about $50,000, maybe a little bit less. So the majority of these dealt with trademark costs. And that $953,000 is just for trademark infringement. And that included $653,000 in compensatory damages and $300,000 in attorney fees and costs. And that is only Carole's attorney fees and costs. That doesn't include all of the money Joe spent unsuccessfully fighting against this lawsuit to get to the point where he still owed almost $1 million to Carole Baskin. Fast forward a little bit of time. In January 22nd, 2020, Joe Exotic was sentenced to 22 years in federal prison. Now, this wasn't for trademark infringement, obviously. Trademark infringement is a civil matter. You can't go to jail for infringing someone's trademark. You can just owe them $1 million or so. So it's different from that. However, the financial implications of owing all of that money did cause Joe to go a little bit perhaps crazier than he was. And he did hire a hitman supposedly for $3,000 to go ahead and kill Carole because he felt that her judgment was kind of stifling him and he couldn't proceed with business as usual. In March 2020, Joe becomes famous. On March 20th, 2020, Netflix's Tiger King: Murder, Mayhem, and Madness was released. It was watched by 34.3 million people over its first 10 days, which ranked as one of Netflix's most successful releases to date. Going forward, just a couple months ago now, in June 2020, Joe lost his zoo. So on June 1st, 2020, a federal court in Oklahoma issued a judgment against Jeff Lowe's company. If you've seen the documentary Tiger King, Jeff Lowe was also a shady character, perhaps, that tried to acquire the zoo from Joe so that it couldn't be taken by Carole Baskin. but the court kind of saw through that and it wasn't a real transfer. So the ruling gave Carole's company ownership of the land, cabins, and vehicles in the location that was formerly known as GW Zoo in Oklahoma. However, it did not give Carole ownership of any remaining cats, just the land. Going in the future, Universal makes a show. Universal Content Productions, the Universal media, is set to produce a limited series adaptation of the Joe Exotic Carole Baskin story. Kate McKinnon is set to portray Carole Baskin, and the show will be based on the second season of Wondery's Over My Dead Body podcast. So you might be wondering, what is the Wondery podcast? Sometimes what happens is a story like this gets told in a few different ways. Obviously, the one that everyone knows about is the Netflix series, but also sometimes some podcasts do things, and it's often cheaper to just license it as being based on a podcast rather than being licensed based on the Netflix show. So that's just what happened in this scenario. Also recently on the news was announced that Carole Baskin will be on Dancing with the Stars, which should be interesting, to say the least. So, now that we know what trademarks are, let's talk about how to identify your trademarks. You should look at, remember, when we talked about trademarks are an adjective, the thing in front of the name. So for you, that could include the name of your business. It could include any slogans you use as part of your business, any sort of guarantees, any product names you have or any services. If you have physical goods, it could be the name of the physical goods. If you have services like SaaS products, it could be the name of that product out there. And if you'll notice, I mentioned both current and future. So you can file a trademark on something you're currently using. However, you can also file what's called an intent to use application. And an intent to use application is an application that you intend to use in the future. So if you have anything, perhaps you're thinking of creating a new product or new brand line, you can file an intent to use application to protect that name so that when you're ready to launch, you already have that name protected. And if there are any issues with that name, you know about them now rather than when you've launched and you get a cease and desist letter from someone saying stop using it or we're going to sue you for $1 million. So how to protect your trademark. Remember in the beginning of this, we went over all the different types of intellectual property, and trademarks, like copyrights, are automatic in a sense. So when you produce something, if you create something, when I finish this video and it's in a tangible form, it's an automatic copyright. It's not registered, but it's called what's a common law copyright. And it's the same for trademarks. If you start a business, you start selling something, selling a product, you might have common law trademark rights. The problem with those is that they're limited, and they're limited to the geographic area that's being used. So if you start a company called Denver Bagels, and you're only selling bagels in Denver, you're limited to what that space is. So you can call Denver Bagels and use the TM, and that's it. Federal registration, meanwhile, protects your use within the entire United States, and you can use the symbol of the R with the circle around it. So what are some additional federal registration benefits? A federal registration creates a legal presumption of your ownership of the trademark and your exclusive right to use your trademark nationwide. The public is put on notice of your claim to own your trademark. Your trademark is listed and searchable on the USPTO website. In some instances, you can record your registration with customs to stop the importation of infringing foreign goods. We mentioned you can use the symbol R, and you can sue someone in federal court for infringing your trademark. So if someone infringes your common law trademark, that common law right is a state right. So if someone else is using the same name in Colorado that you are, you can perhaps stop them from using that mark in Colorado, but you can't stop elsewhere. So let's say you start a business called DEN Bagels instead of Denver, because that might be a bit specific or generic. You just Den Bagels. And it's doing really well, and you decide, you know what, I'm going to expand it to New Mexico, just south of Colorado. And when you go to open a store in New Mexico, you find out that someone else has the trademark for DEN Bagels as a federal trademark, and that's nationwide. So what happens then is they can prevent you from actually expanding your business. So now, even though you might have been the first one to use it, you can't expand outside of your current geographic area because someone else owns the right to that mark in the whole rest of the country. So if there is any sort of possibility of expanding outside, it's often good to secure a trademark because if someone else gets a registered trademark, it's much, 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 much more complicated to stop them from using it. And then how to avoid getting sued. So you can't totally avoid getting sued, but you can reduce. You should do a search before using a mark. Even if you've never heard of it anywhere else, there is always a possibility that someone else could be using your mark somewhere. These searches could include the trademark electronic search system, just to see if someone else has a very similar mark. You can do a Google search. You can search Amazon or other product websites to see if there's a product, if it's a physical product. You can just do a general internet search, such as one using google.com or bing.com to see if someone else has used your mark before. If it is something that's very valuable, I do highly recommend hiring someone to do a search, just because they're more aware of whether something, more aware of helping to interpret the results. You know whether or not something you're doing could be an issue or not. One thing to consider as well is that it's not just a matter of how close your mark is to someone else, but also a matter of how big that company is. So if you have a mark that's much more similar to a mom and pop shop, it might not be as likely that they'll see an issue and take you to court and litigate for years. However, if your company name or product name or service name is pretty far apart from another company, product or service name from a Fortune 500 company, they might be a lot more stringent about enforcing their marks, and they might be more likely to sue you for using that name. So it's one thing to consider when you're using names is not just how close your mark is to other people, but also who's the owner of that and how likely are they to enforce their rights. One option is to do a search of your mark before you start using it or before you file for a trademark application. One way to do that is you can go to the U.S. Patent and Trademark Office website, uspto.gov. And when you get there, there's a drop down on the right side for trademarks. And go over to that, and the first result is Search Trademark Database. Now this brings you to the Trademark Electronic Search System, or TESS. So you can do a basic word search and type in the name of the trademark you want to search. So for this example, I'll do Denver Startup Week and press enter. Now when you're doing a search, you would want to include other terms. So if we were actually searching for Denver Startup Week, we might want to do a search for Denver Startup, Startup Week, Denver Week, and other variations to make sure that we're not just finding the exact term, but also any similar terms. But in this case, this can be a good way to find out if someone's using your exact same mark. So there are 2 trademarks for Denver Startup Week. You can click on them to see the details. This first one is that logo that appears on the slides. And this is called a stylized mark. And it's for public advocacy to promote awareness of entrepreneurship and startup companies. First used in 2016, first use in commerce 2016. You can look at the other one as well. And this is Denver Startup Week, just the name Denver Startup Week, which is a word mark in class 35 for public advocacy to promote awareness of entrepreneurship and startup communities. So sometimes people can file a trademark for both the logo they have, which is a stylized form, as well as just the words themselves. Another thing you can do is file an intent to use application to secure your mark in advance. I mean, it's very easy to do. The filing fee is only $275. You can hire an attorney to help you with it. And when you file an intent to use, once it's allowed, you have up to 3 years paying a small fee of, I think it's right now about $100 every 6 months to extend that, going up to 6 years, as long as you do actually have a bona fide intent to use that mark, so that when you're ready to launch, you don't suddenly get a cease and desist, and then you have to contact all your clients, you have to contact your distributors, your production, change all the names around, or pay a huge amount of money to settle it with the other person. So it's an inexpensive way of avoiding trouble down the road. And also be proactive in notifying potential infringers. Sometimes it's a nice idea when you have a new company and it gets written up and they might accidentally use the name of your company as a sort of service or product generally that's being used, especially if it's unique. And you might find that other people start using it. The problem is, if you stop protecting your mark, other people can come in and start using it, and then it might become genericized. So if you try and send a cease and desist to someone, and they say, hey, we've been using this mark for 5 years, here's 20 other companies that are also using that mark, it's a lot more difficult at that time to enforce it. And if you even try and file a lawsuit, you might run into trouble with having your mark ruled as, just basically describing the general class of goods. Thank you so much. My name is Chris Weiss for Denver Startup Week Founder Track.